The President. Questions. Question 1, Mr. Ma Fung-kwok. Thank you, Mr. President. The economic contribution of the cultural and creative industry CCIs in terms of percentage share in gross domestic product increased from 3.8% in 2005 to 4.9% in 2012, and the employment in such industries as a percentage in the total employment during the same period increased from 5.1% to 5.5%. Some members of the industries have pointed out that although CCIs are emerging pillar industries in Hong Kong, the room for survival of such industries has been severely compressed, and their development has been seriously constrained due to the tight supply of land. In reply to my question in October last year, the Chief Executive indicated that the development of creative industries at the Lok Ma Chau Loop, the loop, would be considered. Regarding the provision of land for the development of CCIs, will the government inform this Council, A, of the current progress of the planning work for the loop, how CCIs are expected to benefit from the development of such area, whether the authorities have conducted any assessment on the land required for the development of such industries, if so, how such demand for land will be met, if not, of the reasons for that. 2, whether it has considered strengthening cooperation with the mainland departments and, on the premise of comprehensive infrastructure, renting sites on the mainland for establishing parks for emerging industries which will mainly be managed by the Hong Kong side, so as to take forward the development of CCIs of Hong Kong. And 3, whether the Consultative Committee on Economic and Trade Cooperation between Hong Kong and the mainland has, since its establishment in October last year, discussed how to foster the development of CCIs, if so, of the details, if not the reasons for that, given that some members of the industries have proposed the construction of a film and TV city in Nansha, whether the committee has discussed this proposal, if so, of the details, if not the reasons for that. Secretary for Commerce and Economic Development. My reply to the questions raised by Mr. Ma Fung-kwok is as follows. 1 and 2. The CEDB is responsible for promoting the development of creative industries. Creative industries cover advertising, architecture, design, digital entertainment, film, music, publishing, and printing, television, etc. The Home Affairs Bureau, HAB, supports the development of arts and culture in Hong Kong, covering performing arts, visual arts, literary arts, and intangible cultural heritage. Creative industries under the purview of CEDB cover different sectors. The business nature and scale varies from one creative sector to another. Creative establishments are mostly small and medium enterprises or operated on a self-employed basis. With the exception of a small number of enterprises, such as television stations, film studios, etc., which require larger parcels of land, creative establishments are mainly scattered in commercial and industrial buildings in different districts. Hence, the demand of creative industries for office facilities and business premises has largely been reflected in Hong Kong's overall demand for commercial and industrial buildings. CEDB has not conducted any specific assessment of the land required by creative industries. To develop creative clusters, the government and relevant organizations offer support to selected creative sectors by provision of office facilities and support services. Cyberport and InnoCenter lease working space to digital entertainment and design companies, respectively. Incubation programs for startups are also available in both creative clusters. In addition, the former police married quarters on Hollywood Road, PMQ, revitalized with the government's funding support, will commence operation in the first half of this year, providing studios to some 100 establishments and persons engaged in creative industries. As regards the development of the arts and culture, HAB promotes the development of cultural software through supporting the development of quality arts programs, audience building, arts education, the grooming of arts talents, and cultural exchange. HAB provides funding support to small, medium, and major art groups and individual artists through direct subvention and grants provided through the Hong Kong Arts Development Council and under the Arts Capacity Development Funding Scheme. The Leisure and Cultural Services Department, LCSC, engages arts groups and artists in the programs and exhibitions presented by the department and operates cultural facilities including performance venues, museums, centers of visual arts and public libraries, etc. HAB also provides funding support to projects of providing art space for arts groups and artists, such as those implemented by the Jockey Club Creative Arts Center and the Hong Kong Arts Development Council. The government takes into account the needs of creative industries when planning for the land uses of new development areas. The Lok Ma Chau Loop mentioned by Mr. Ma Fung-kwok is a case in point. The final proposals of the planning and engineering study on development of Lok Ma Chau Loop, the study, were promulgated in July 2013. According to the recommended outline development plan (RODP) of the study, the LMC Loop will be developed with higher education as the leading land use, complemented by high-tech research and development (R&D) and cultural and creative industries (C&C). The recommended land uses for the loop have taken into consideration the advantage of its strategic location at the boundary district of Hong Kong and Shenzhen in attracting talents in knowledge, technology, and creative industries, and through development of the loop to facilitate knowledge and technology exchange between the two cities. Under the RODP, about 8.6 hectares of land, providing a maximum gross floor area of 411,000 square meters, is earmarked for high-tech R&D and C&C uses, in which interchangeability amounts to 2 uses is allowed in order to provide a flexible land use framework to meet future market demand. The works ahead will include preparation of a statutory outline zoning plan and detailed engineering design of the advanced works. We shall endeavor to commence as early as possible part of the advanced works to facilitate site formation and building construction so that part of the facilities in the loop can be put into early operation. Moreover, Kowloon East is being transformed into another core business district to support Hong Kong's long-term economic development. The Development Bureau will capitalize on the transformation of Kowloon East and identify sites to support the development of arts, culture, and creative industries. For example, the Development Bureau will convert the sites underneath the Kwun Tong bypass for arts and cultural events and use by creative industries. Hong Kong has a highly open market, quality business support services, well-established intellectual property regime, the rule of law, and free flow of information, providing an ideal business platform for creative establishments. The government is committed to fostering a favorable environment in Hong Kong for developing creative industries and has no plan to establish parks on the mainland for Hong Kong's creative industries. Part 3 of the reply. The responsibility of the Consultative Committee on Economic and Trade Cooperation between Hong Kong and the mainland is to advise the Hong Kong SAR government on matters relating to strengthening cooperation with the mainland in trade, economic, and other relevant areas. Topics to be discussed are determined by the committee. Since its establishment, the committee has not discussed how to promote the development of cultural and creative industries in Hong Kong or the construction of a film and television city in Nansha. Thank you, Mr. President. Mr. Ma Fung-kwok. Mr. President, Hong Kong has limited resources as far as land is concerned, and this poses great constraint on the arts and culture sector. The film sector doesn't have the sufficient land to carry out advanced preparation of filming works. Some comment that costumes, props, etc. require certain larger sites, but they are unable to afford the high rental. And in the long run, in terms of advanced and post-filming production, the film sector finds it hard to survive. In the reply, it is said that there is no plan to establish a park for cultural and creative industries, and there is no discussion on this topic. My question is whether there is study on cooperation between the two governments to create a cultural and creative industrial base for the development of the film industry. Secretary, Mr. President, in my reply, I already mentioned that to develop creative clusters, the government provides various support to the sector. For example, we provide office facilities and support services. We also, in relation to business startups in the sector, we launch incubation programs as part of the support. So, apart from Create Smart, with an injection of $300 million in the Film Development Fund, we also assist the film industry, and we also have the working group under the EDC on arts and creative industries development. Mr. Ma Fung-kwok mentions cooperation between the two governments. This is exactly the Consultative Committee on Economic and Trade Cooperation between Hong Kong and the mainland's responsibility in exploring development opportunities in the related areas in Nansha and Hengqin, and they're actively exploring room for strengthening cooperation. We understand that land supply is limited in Hong Kong, and if possible, if the creative industries can utilize the resources on the mainland for its development, we're happy to strengthen communications. Chen Yuen-han. Thank you, Mr. President. I have two questions in relation to the administration's reply to Mr. Ma Fung-kwok. Please raise one question first. All right, so be it, one question. Just now, Secretary said that the core business district will be created in Kowloon East and that a space will be created underneath the Kwun Tong bypass. Well, I also make this proposal. However, my original proposal is to link this to the Kwun Tong area. And the Polytechnic University professor recently came up with a large plan. That is how to link the site underneath the bypass with the surrounding areas in Kwun Tong, and you could make use of the space underneath the flyovers for use by creative industries. And I discussed with the sector, we can follow the example of New York. Say owners of industrial buildings may be given a certain relaxation on the plot ratio if they're willing to provide space for the industries. So why don't you consider it? I think, yes, you have been active in exploring the use of land under the flyovers, but young people are angry because the government doesn't help them, and rather they are driven away. So why don't you consider it, Secretary? Thank you, Ms. Chen Yuen-han, for the question. Indeed, in Kowloon East, I also note creative clusters being formed there in Kowloon East, in particular in Kwun Tong. They have formed a community, and they have now moved in industrial buildings to establish their communities. In fact, the Development Bureau has been exploring more sites in Kowloon East to support the development of creative industries. For example, for the Kai-Tak Fantasy in Kowloon East, space has been reserved for the development of the culture and creative industries. And the mode of development is yet to be determined. And Ms. Chan is concerned about this. For example, for the former Tai Ham village site, last September, the administration proposed to Wong Tai Sin District Council in relation to the development plan for Simei Street, the bus terminus would be reprovisioned to vacate the site with a gross floor area of 13,150 square meters, which can be used by the creative industries. So the administration also understands the needs of the sector, and we believe Kowloon East is a suitable location. Your question is not answered. He talks about Tai Ham Village. I commend him for that, but I'm talking about Kwun Tong. If the space under the flyover and industrial buildings could be used for development, that would be better. But please answer me on Kwun Tong industrial buildings. Secretary, please respond to the point about industrial buildings in Kwun Tong. In my main reply, I already said that the creative industries cover a very wide scope. The office space required by the industries are not so different than other business operations. So The overall demand for commercial and industrial buildings in Hong Kong have largely reflected the need or the demand of creative industries for office facilities. As for the future development in Kwun Tong to maximize the use of space, we are actively following up on this suggestion. Mr. Christopher Chung, I'd like to follow up on the second and the third part of the reply. Now, I want to tell the Secretary that it has to do with the supply chain. The government is only promoting the film sector. What about other related industries, art galleries, performing arts, etc.? If they want to have performances or have exhibitions on the mainland, the administration currently provides no assistance. The crux of the problem is that arts and culture is under the purview of the Home Affairs Bureau, whereas tapping mainland markets and developing business opportunities are under the purview of your Bureau, Secretary. So can you work with the HAB and explore this possibility? Apart from the film industry, can you assist other creative industries in tapping the mainland market? And can you ask the LCSD to deploy some staff to the ETOs on the mainland to strengthen cooperation with our mainland counterpart in strengthening cooperation and looking for available sites? Please be seated, Mr. Chung. You have asked your question. Secretary. In terms of the administration's work, the CEDB and the HAB do cooperate on this issue. We provide support on various fronts to the creative industries. As I said in the outset, the creative industries cover a wide spectrum. They include architecture, design, music, film, publishing, etc. Different creative community has different need, and the CDB and the Trade Development Council also brings designers to different places for the purpose of promoting their business. So whether we need to deploy staff at the ETO, I don't think at present there is such a need. We can, through other channels, help them tap overseas markets. Mr. Chung, Secretary hasn't answered my question. Can you give me one more example how you can help artist groups and artists in Hong Kong in their activities on the mainland? Otherwise, if we just well, Mr. Chung, you have asked another question. Please be seated and press your button if you want to ask a second question. Answer my question, please. He hasn't answered my question. Mr. Ronnie Tong. Sorry, speaker's not coming through. All right, sorry. Now, Mr. Ma asked about the Lok Ma Chau Loop development. However, in the Secretary's reply, it's very perfunctory. No information is available. In the Donald Tsang era, the administration proposed to develop the higher education industry at the Lok Ma Chau Loop, and at that time it was suggested that more than one higher education institution or even university can be built there. But since the Donald Tsang era ends, we have heard nothing about the development of the Lok Ma Chau Loop. So about developing higher education in the Lok Ma Chau Loop, Secretary, is this still the government's plan? If so, will there be more than one university being built there to make up for the shortfall of university places in Hong Kong? Secretary, thank you, Mr. Tong, for your question. In my main reply, I mentioned that the Lok Ma Chau Loop development will be carried out with higher education as the leading land use. Today's question is about the development of the cultural and creative industries in Lok Ma Chau Loop. And therefore, the development of Lok Ma Chau Loop will also be complemented by high-tech industries, R&D, and cultural and creative industries. At present, I don't think there is a specific or detailed plan for the Lok Ma Chau Loop in terms of operational and planning matters and the splitting of funding. We're still at this stage. We haven't reached a stage of how many universities should be built. Mr. Donald Tsang's proposal was very clear. Now nothing's mentioned. Does it mean that Mr. Donald Tsang's proposal has been scrapped? Mr. Tong, I think Secretary has replied to your question. If you're not happy with his answer, please follow up on other occasions. Mr. Charles Mok. Secretary just mentioned that Lok Ma Chau Loop will be developed with higher education as the leading land use, complemented by high-tech research and development, etc. If so, I don't think we should confine it to the planning for land use. I think it's a good opportunity for us to develop a smart city or smart area. This is just the initial stage. Secretary, will you incorporate the objective of building a smart city into the plan to create opportunities for the innovation and C&C sector? If so, how will this be done? Secretary, as I replied to Mr. Tong's question just now, the Lok Ma Chau Loop development is a cooperation plan between Hong Kong and the mainland. We need to further discuss the details, including the mode of development, implementation, management, and also the splitting of costs. Whether it should be developed into a high-tech area, we still need to explore this idea. Mr. Chen Kam-lam. Mr. President, from the Secretary's reply, we can see that the administration provides various support to the CCIs. However, Secretary, have you considered this? If the sites underneath the Kwun Tong bypass would be used by the industries, together with other measures, these enterprises in the creative industries may need to go through the process of identifying sites, etc. They are paying very high rent in their present premises. How do you help them in resolving the present difficulties? Will there be any rent allowance or subsidies? Secretary, the administration also notes that there are views from the community that cheap land or office space or rent concessions should be offered to the creative industries. However, we don't think this is a long-term solution to enhancing the competitiveness of the creative industries. We believe the role of the government should be to upgrade the overall competitiveness of the creative industries and the grooming of talents, developing new markets and supporting new business startups. So as I said just now, we have the Create Smart, and we have injected a new round of funding to support these measures. And we also have a working group under the Economic Development Council to support the objective of enhancing competitiveness of the creative industries. We've spent over 23 minutes on this question.
Question 2, Mr. Albert Chan. President, members of the public have pointed out that the government, on one hand, encourages the public to resolve disputes by arbitration or mediation, but, on the other hand, resorts only to judicial proceedings in dealing with disputes with the public, such as on compensation for land resumption. Quite a number of members of the public cannot afford the high legal costs and hence have no choice but to accept the compensation proposals offered by the government. These members of the public have also pointed out that in Canada, an arbitration or mediation mechanism is in place for resolving disputes arising from land resumption by the government, and they propose that the government should follow the relevant practices. In this connection, will the government inform this Council, A, of the reasons for not resolving by arbitration or mediation those disputes that involve land resumption by the government, B, of the reasons for government taking different stance towards dispute resolution among members of the public and those between the government and members of the public, and C, whether it will consider introducing an arbitration or mediation mechanism by way of a pilot scheme to deal with certain common disputes between members of the public and the government. If it will, of the details; if not, reasons for that. Secretary for Justice. My reply to the three parts of the question is as follows. A. Currently, the government resumes private land for public use pursuant to the relevant laws of Hong Kong, including Lands Resumption Ordinance Cap 124, Roads, Works, Use and Compensation Ordinance Cap 370, etc. These ordinances provide for payment of compensation for the private land resumed or interests affected. In general terms, statutory compensation. The entitlements to compensation, the procedures involved, as well as the basis and principles of assessment of the compensation, are set out in the relevant ordinances, while the authority for final determination under the ordinances rests with the Lands Tribunal. In addition, the government has also put in place a system of ex gratia land compensation and allowances as an alternative to statutory compensation, with a view to minimizing the hardship faced by former owners and affected parties. The assessment methods and eligibility criteria of the ex gratia allowance are established with the approval of the Legislative Finance Committee. Experience shows that the ex gratia compensation and allowance system has been working well. On one hand, it addresses the reasonable needs of the affected parties, and on the other, reduces the need to claim statutory compensation. If the parties do not accept the ex gratia compensation offer made by the government, they may make a claim for statutory compensation. Generally speaking, the Lands Department, Landsd, would negotiate with the former owners and affected parties on matters related to the claims. Parties may take their claims to the Lands Tribunal for final determination of quantum of statutory compensation if agreement cannot be reached with the government. In other words, in assessing the amount of statutory compensation, that is the quantum, Landsd is obliged to follow the principles set out in the respective ordinances and the court rulings made in land resumption cases. Likewise, in assessing whether an individual is entitled to ex gratia payment, and in determining the quantum of compensation, Landsd cannot deviate from the established principles and methods regarding eligibility and criteria for the ex gratia compensation allowances. Under such circumstance, room for arbitration and mediation is limited. For this reason, arbitration and mediation may not necessarily enhance the flexibility of the government's handling of disputes related to statutory compensation claims. Notwithstanding, Landsd may consider requests for handling statutory compensation claims by mediation if claimant so requests. But the mediation process and decisions made cannot affect the government's and the Lands Tribunal's exercising of power under the law. B. The administration is always keen to promote the use of arbitration and mediation as a means of dispute resolution, and has encouraged bureaus and departments to use these means for resolution of disputes involving the government in suitable circumstances. In relation to mediation, Practice Direction 31 on mediation and Practice Direction 18.1 on personal injuries list issued by the judiciary provide that parties to legal proceedings have to consider engaging in mediation for settlement of the disputes. These two practice directions are effective from January 2010 and April 2009 respectively and apply to the government. Therefore, in civil proceedings to which these practice directions are applicable, the government will comply with the practice directions and actively engage in mediation with a view to settling the disputes concerned in suitable circumstances. To this end, the Department of Justice has enhanced training and will continue to work closely with other bureaus and departments to organize mediation training courses targeting their specific needs. In relation to arbitration, there are at present provisions under some ordinances, including the Tongchong Cable Car Ordinance, Cap 577, and the Eastern Harbour Crossing Ordinance, Cap 215, which provide that if disputes arise in respect of the matters as specified, the government and the parties concerned shall use arbitration to resolve the disputes. There were cases in which arbitration was used pursuant to the ordinances. In addition, the government has in fact adopted mediation or arbitration as dispute resolution mechanism in other fields. For example, the standard clauses under government public works contracts and consultancy agreements provide that the contracting parties may resolve disputes by mediation or arbitration. C. Although arbitration and mediation are two effective means of dispute resolution, they may not be applicable in all types of cases. In relation to some cases involving the government, such as judicial review applications, they involve important legal points or significant public interest. It's necessary to refer the case to the court for an authoritative ruling made in public, so as to lay down legal basis and guidance for future reference in handling similar cases. Nevertheless, depending on the needs, the government will consider introducing schemes for mediation or arbitration in suitable areas. As mentioned in the 2014 policy address, in respect of lease modification applications submitted by private landowner, the government will introduce a pilot scheme for arbitration on land premium to facilitate early agreement on land premium payable by way of arbitration so as to speed up land and housing supply. In addition, the Steering Committee on Mediation set up in late 2012 will monitor the implementation of the existing measures and consider new initiatives to promote and foster the development of mediation in Hong Kong. Thank you. Mr. Albert Chan. Well, obviously, the government's reply refers that conglomerates and developers can resort to mediation, but not members of the public. It's been 14 years. Owners still cannot get compensation. These small owners ask for mediation and arbitration, but their requests have been turned down. Arbitration and mediation aims at driving down the legal cost so that the case doesn't have to go to court and there is a mechanism for the case to be dealt with. But the government rejected requests by small owners to resolve the case by mediation and arbitration. The government, relying on their huge legal team, to scare members of the public away so that they don't want to take the case to court and they will just accept whatever they are offered. Well, 4 years ago, I have given you my stance and my submission saying that when it comes to land disputes, arbitration and mediation should be used. Will the government reconsider? They want to turn Hong Kong into an arbitration and mediation center, but they should not scare the public away using their huge team and abundant resources and deny members of the public the avenue of arbitration and mediation. Secretary for Justice. First, I'd like to clarify that the government does not have the intention to scare members of the public away with judicial proceedings. When it comes to the choice of court proceedings or arbitration and mediation, we take into account the nature of the dispute and the individual circumstance of the case. We do not solely rely on the fact that it involves members of the public or conglomerates in deciding whether we use legal proceedings, mediation, or arbitration to resolve the case. And I'd like to give a clear answer to Mr. Chan's question. When it comes to promotion of arbitration and mediation, we want to strengthen Hong Kong's position as a center for dispute resolution in Asia. We highlight the benefits of arbitration and mediation, and this is one of the reasons why we promote this. Another benefit is that arbitration and mediation use less time and cost compared to lengthy legal proceedings. So in suitable circumstances, we are happy to use mediation and arbitration. But I'd like to say that whether it is arbitration or mediation, they are different means to resolve disputes. And as to when to use which depends on the circumstances. You may be a strong advocate of arbitration or mediation, whether you're a lawyer or in the dispute resolution field. They cannot say that arbitration or mediation is a panacea. We have to take into account the facts of the case. That's why there is a dedicated working group under the Steering Committee on Mediation to consider what plans or schemes to introduce in the future. I can tell you that the Steering Committee on Mediation is working on the use of mediation in medical cases and building management. And we will conduct studies, and that also includes water seepage. Mr. Ibrahim Sheikh. In the last paragraph of the main reply, it mentions about making use of arbitration to resolve land premium disputes. When will this scheme be launched? And what are the details and criteria? Secretary, our current plan is that in the middle of this year, 2014, we will announce the details of the pilot scheme. We are still studying the details of the proposed scheme. After that, we will consult the trade before we announce the details of the scheme. Mr. Dennis Kwok. Thank you. I see that in the third paragraph of the main reply, he mentions about the importance of judicial review. And he also mentions that when it comes to dealing with important point of law and those with significant public interest, judicial review cases are very important. And the court very often have to make authoritative ruling in these cases. But when it comes to judgments of judicial review cases, some legislators or political parties will say outside the court that people abuse judicial review applications and our judiciary. In this regard, will the government make further clarifications and enhance the civic education so that the public will know that when it comes to the process of dealing with judicial review and the criteria used by the Department of Justice, the Legal Aid Department, and the court, so that the public will have a better understanding of the situation? Secretary, I thank Mr. Kwok for his question. First, I can certainly say that the government respects the right of the public to take out judicial review. And this is an important part in our rule of law. Mr. Kwok mentioned about cases involving judgment of judicial review, and it triggered public discussion. It's healthy to have discussions in the community. We are a pluralistic society. Different people will have different views, and by expressing their views, it shows that we have freedom of expression. And on different occasions, people express their views on these cases is allowed under the law. When it comes to civic education, we've always supported civic education. And we've always wanted to enhance the understanding by the public of the law. We will continue with our work, which include judicial review under civil proceedings. Ms. Priscilla Leung, what is the third part of the reply? I think it has digressed from the point in the question. Today we're talking about arbitration. In the community, a lot of people face a problem. They cannot afford the legal costs, while the other party has abundant resources. I mentioned in a motion in 2009 that it should not be just about mediation. Mediation is not binding. Arbitration is. So when it comes to land disputes and disputes involving OCs, owners of corporations, and I'm glad to hear about medical cases that you would like to use mediation. But mediation itself is not binding. And you now have launched the pilot scheme for arbitration on land premium. Of course, I welcome this pilot scheme. But can the scope be expanded to other areas? Can I hear an answer from you that you are exploring the possibility of expanding the coverage on OC disputes and issues involving significant public interest? Who is to take this question? Secretary for Justice. Thank you. Application of arbitration, as I said, depends on the case. Ms. Leung mentions about owners' corporation disputes, but there are many different types of cases. We do not rule the possibility of the use of arbitration in dealing with these cases. When the parties would like to use arbitration, of course, the government will encourage that, and there is nothing that stops them under the law from doing it. But please understand that litigation, mediation, and arbitration are different. Arbitration and litigation attracts considerable legal cost, whereas a mediation will involve a lower cost. So our emphasis is first on mediation. Mr. Tong Li-jie. Thank you. According to Cap 124 Lands Resumption Ordinance, parties affected and the government, if they cannot agree on the quantum within a reasonable time, the government can make an advance payment to the parties affected. I want to ask, under the existing policy, this advance payment, will it be the entire amount based on the initial assessment to tie owners over the difficulties? And if not, who is to decide that, the quantum? Secretary for Development. When it comes to the interim payment, it's based on the evaluation and assessment of the Lands Department. But in some cases, apart from the evaluation, in certain circumstances, there may be ex gratia payment. But the ex gratia payment is a choice of the parties involved. They can choose to have the ex gratia payment and not statutory compensation to resolve the dispute. But if this dispute is still ongoing, they will not be given ex gratia payment. The interim payment will depend on the assessment of statutory compensation. Mr. James Tian. I rarely agree with Mr. Chan, but on this occasion I do. The government says that in relation to Cap 124, and 372, they are in relation to land resumption and roads. But they refer to statutory compensation. Over the years, I see that the amount is always below the market rate. But they have a different approach when it comes to developers. You ask for 1 billion and you counteroffer by 600 million. And they can easily spend hundreds of $1,000s in a court case. So if you don't have the resources and you are kind of forced to accept the compensation is unfair. In the policy address, there is the pilot scheme for arbitration on land premium. I don't think it should only be applicable to developers on land premium. Why can't it be expanded to wider scope so that members of the public can make use of this scheme to resolve disputes? Say, for example, you offer $100,000 and it's not taken, and then you counter offer $120,000, then the case will be resolved because it's accepted. Secretary for Development. As the S4J said, when it comes to the formulation of policies, the administration will not take into account the identity of the party affected, say, for example, developers vis-a-vis members of the public. When it comes to the we will take into account the conditions set down in the policy and the ordinance. There are provisions setting out the criteria, principle, and calculation of quantum under the ordinances. Say, for example, land resumption in the new territories, there is ex gratia payment. It's available not just for owners, and in some cases, occupiers can get it as well. And as to who may make an application, we have to come to the LegCo to get funding approval before the parties get the payment. So whether it is statutory compensation or ex gratia payment, we have to go through the vetting of the LegCo, and the criteria is quite stringent. Everything is provided for and set down. And that's why mediation, there is little room for a mediation. This room is limited. Based on past experience, when it comes to ex gratia payment, there is a high percentage of acceptance. Say, for example, land resumption in the new territories. There are 4 areas when compensations are made, and the acceptance rate is as high as 95%. In urban areas, it's mostly related to urban renewal projects. When the URA, the Urban Renewal Authority, received applications that reaches a certain threshold, then they will deal with it. And for those who, for cases that do not reach the threshold, then the case will go to the government. And very often, over 80% of the parties involved will accept the offer made, which are quite good. And the URA only accepts such cases, and there is the remaining 20%. And the case will be dealt with by the Lands Department, and about 48% of them accept the offer. So to a certain extent, the current mechanism is working well. Mr. Tian? Well, I asked a specific question and it's not answered about arbitration on land premium. Will the scope be expanded to members of the public and not just developer? My understanding is that the Secretary said the current mechanism is working well. I think your question has been answered. Secretary, would you make it clear whether you will or will not expand the scope? In relation to the pilot scheme for arbitration on land premium, Regardless of the identity of the owner, we have the same treatment, whether they are companies or individuals, as long as they are the owners. And when discussing with the lease and modification applications, we treat them in the same way. We have spent almost 26 minutes on this question.
The third question, Mr. Ip Kin-yuen. Mr. President, quite a number of primary and secondary school teachers have related to me that due to an excessive number of teaching lessons and the need to deal with copious amounts of non-teaching work, they work excessively long hours and do not have adequate rest time. As a result, such a situation not only affects teaching quality but also makes them unable to spare time to take care of and provide counseling to individual students. These teachers opine that given the sound financial position of the government present and ample supply of qualified teachers, the authorities should expeditiously implement measures to improve the class-teacher ratios of secondary and primary schools and increase the number of permanent teaching posts in the teaching establishments as to relieve the problem of excessive workload of teachers. In this connection, will government inform this Council A of the criteria based on which the authorities set the existing class-teacher ratios of secondary and primary schools, whether they have assessed if such ratios need to be improved, if they have of the assessment outcome and the improvement measures, if not, the reasons for that? B, given that the incumbent chief executive undertook in his election manifesto that he would suitably increase the number of teachers, thereby enabling teachers to devote more time to students and to their own professional development, whether the authorities have conducted studies or reviews on the expansion of the teaching establishment as well as draw up relevant measures and timetable, if they have of the details, if not, the reasons for that, and see, as some members of the education sector pointed out that at present, quite a number of young people aspiring to join the teaching profession can only be appointed on fixed-term contracts due to the lack of permanent teaching post vacancies, and there has been a persistent wastage of young teachers if they have not been provided with a stable working environment to give full play to their strength and expertise. With the Bureau is concerned about such a situation and how the authorities will solve the succession problem of teaching manpower in future. Secretary for Education. Mr. President, my reply to the honourable member's question is as follows. A. When formulating policies concerning school resources, including teacher manpower, the Education Bureau actively listens to the sector's views and considers the actual needs and resource priority. We strive to create an enabling environment for quality education. To take the implementation of the new senior secondary and SS academic structure as an example, after extensive consultation with sector in 2004 and 2005, we decided to revise the class-teacher ratios in the 2009-10 school year and further improved the ratio for senior secondary levels to 2 teachers per class starting from 2012-13 school year. Cash grants such as the Senior Secondary Curriculum Support Grant and the Diversity Learning Grant are also disbursed on a recurrent basis to support schools and teachers. Regarding primary schools, as a result of our consultation with the sector, we have provided schools with additional teaching posts in their permanent staff establishment since 2006-07 school year for the implementation of specialized teaching, hence increasing the class-teacher ratio of whole-day primary schools to 1.5 teachers per class. Posts of curriculum leaders were also created in the permanent staff establishment with effect from 2007-08 school year. All these are the results achieved through our consultation with sector. In reviewing the manpower resources of schools, we have to look beyond the class-teacher ratios and take a holistic view on resources and other support measures available, including the provision of additional regular teachers under various education policies and various cash grants for employing additional teaching staff. Based on their situations and development needs, schools can deploy these cash grants for employing additional teachers and supporting staff on top of the teaching staff establishment, or procuring services to reduce the workload of the teachers. As in the past, we'll review schools' manpower needs in a timely manner to help schools implement poverty alleviation and other learning supporting initiatives. It has been announced in the 2014 policy address that starting from 2014-15 school year, will provide public sector primary schools with an additional recurrent grant equivalent to the salary of a clerical assistant to relieve the administrative workload of teachers. We'll also provide the public sector's schools operating senior secondary classes with an additional recurrent grant equivalent to salary of a graduate master mistress to strengthen life planning education. These targeted support measures are introduced having regard to the sector's views, be a number of important initiatives implemented by the Education Bureau in recent years. For example, small class teaching in primary schools and reduction of the number of students allocated per secondary one class have had a direct impact on relieving teachers' workload. The average student-teacher ratios of public sector secondary and primary schools have been lowered from 18.0 to 1 and 18.4 to 1 respectively in 25-6 school year to the estimated 13.8 to 1 and 14.2 to 1 respectively in 2013-14 school year. Meanwhile, the unit costs for subsidized places in aided secondary and primary schools have increased by about 62%, 92% respectively, growth from 33,340 and 24,640 in 2005-6 financial year to 54,170 and 47,320 in the 2013-14 financial year. With continuously improving student-teacher ratios, teachers can devote more time to take care of students and pursue professional development. It is anticipated that the ratios will be lowered further when initiatives on small class teaching for primary schools and reduction of number of students allocated per S1 class for secondary schools are gradually extended to classes in high levels. Furthermore, under NSS curriculum, subjects are often taught in a flexible manner in subject groups. The average size of teaching groups for a majority of subjects is maintained at 25 or below, which has significantly increased the opportunities for teachers to take care of individual students. We will keep monitoring the school situation from time to time, improve the teacher manpower resources according to actual needs as and when necessary. As committed at a meeting on education panel last June, I've conveyed the sector's concern about teacher manpower to Education Commission, which has also discussed the issue at its meeting in February 2014 and will continue to follow up the matter. The Bureau has been very concerned about supply and demand of teachers. We'll take into account the changes in student population in the coming 10 years and adjust the number of government-funded teacher education places so as to maintain balance and stable supply and demand of teachers. We've also been requesting schools to call priority to employing teachers with teacher training. The data of recent years revealed that there are on average about 2,000 teachers leaving the profession each school year due to retirement, further studies, or other personal reasons. The vacancies thus arising are adequate for absorbing the newly graduated prospective teachers. In response to a transient decline in secondary school student population in the coming few years, the Bureau has implemented a basket of targeted relief measures in 13-14 school year. These measures have effectively enabled the schools to retain teachers within establishment, thus minimizing the competition between surplus teachers and prospective teachers for posts. Furthermore, with the anticipated gradual increase in primary school student population, implementation of small class teaching in primary schools, and provision of additional resources in the next year, as announced in policy address this year to strengthen support for non-Chinese speaking students and life planning education and career guidance services, all such are conducive to increase in the overall number of posts for absorbing fresh graduates. We anticipate normal turnover can be maintained as a whole in the coming few years. In recent years, the number of young people joining the profession has been steady. Nearly 90% of those newly joined each year are at the age of 29 or below, while 50% of such teachers are at the age of 25 or below. Besides, most of the serving teachers of primary schools are between 30 and 40 years old. Most secondary school teachers are evenly distributed into various age groups from 25 to 45. As seen, there is no evidence showing a succession problem in the teaching force. As for work stability, about 90% of secondary and primary school teachers are employed under the staff establishment. According to information of 2012-13 school year, 60% of the teachers employed under staff establishment for 5 years or less are at the age of 27 or below. Overall speaking, teaching has remained a relatively stable profession. Thank you. Mr. President, on 5 occasions, the Secretary in his reply mentioned extensive consultation with the sector, but on no occasion has the largest union for teachers been consulted. So can it be regarded as having regard to the sector's views, I want to point out that the crux of the matter is we want to make the number of teaching lessons reasonable and the workload reasonable for teachers so as to raise quality of teaching. Well, in fact, we have the most serious problem of workload. A teacher almost teaches 30 lessons, 28 for mainland and 20 for the mainland, 28 for Taiwan. Now, if we don't review the class-teacher ratios, does it show that the Bureau thinks that the fragmented approach can address the problem of excessive workload and the excessive number of teaching lessons? I want to know whether there is data to show that the workload has been brought down to a reasonable level. Secretary, thank you, Mr. President. Thank you, Mr. Yip, for your question. As far as workload for teachers is concerned, we consider a number of factors. First of all, we have permanent teaching posts, and we have also got a number of cash grants, and we have also got specific subvention. And then in reviewing the new senior secondary academic structure, we'll look at the quantity of workload. We'll also look at the impact of school-based assessment on teachers in accordance with feedback from teachers and principals. We'd like to reduce that so as to lower the level of workload. And thirdly, in relation to the overall workload of teachers, the issue has been forwarded to the Education Commission for formal discussion. The Commission has representatives from all stakeholders. Thank you. Mr. President, I think the Secretary is merely repeating the measures already contained in his main reply. Which part of your question hasn't been answered? I would like to know whether he has got data to show that the workload of teachers has already been brought down to a reasonable level. That's about the outcome. Thank you, Mr. President. I would like to say that I have missed one point, and that's about the number of teaching lessons. We did look into the matter in great depth. In South Korea, 26 to 27 lessons, but then they have 35 to 40 minutes per lesson. When compared to 40 to 45 minutes a lesson, the quantity is different. Mainland, the situation mainland, other than the teaching lessons, mainland teachers also spend a lot of time on research and development. This is not the same elsewhere. Mr. Shet Lai Him. Thank you, Mr. President. I read the question as well as the reply of the Secretary. I don't think the Secretary has really addressed the question. I think the quantity is affecting the quality of teaching. And I want to know when we will practice small class teaching so the teachers don't need to worry about their job security, in particular those contract staff. A lot of young people have been put off in joining the teaching force. So when are you going to introduce small class teaching? Secretary. Thank you, President. Thank you, Mr. Chair. We have had 6 years of experience of rolling over small class teaching in primary schools year by year. We are now reviewing the experience. When it comes to secondary school education, I think this has also been mentioned in my main reply. That is, for secondary schools, in particular for senior secondary classes, they have teaching groups. So sometimes in a group you have only got a dozen of students only. If you practice more class teaching, and that would become a problem. And in fact, when it comes to teaching groups, I think the average size is around about 25. I think this is a very important point. And then we have a policy to support the teachers, and we are reducing the number of students allocated per secondary 1 class. So surplus teachers are able to take up further studies, and such an arrangement means that the workload of teachers can be lowered to a reasonable level. Dr. Helena Wong. Thank you, Mr. President. Many young people have told us that they would very much like to become teachers, but it's very difficult for them to find a post. Now, in the third part of your main reply, Secretary, I don't think you have addressed the question seriously. You simply say that in the policy address, we are going to strengthen the support for non-Chinese speaking teachers, and there will be life planning education. But then they are for the short term, and therefore schools dare not hire teachers under staff establishment on a permanent basis. Now, you may very well say that those who join the force are young, but then they don't have a prospect because they never know whether they can have the contracts renewed. So there's no security. Therefore, young people dare not join the teaching force. Now, even if you want to take on the task, there is no security. Ms. Wong, please raise your question. Can the Secretary tell us clearly, in the past 5 years, I want to know, for young graduates, how many of them have been able to take up a teaching post on a permanent basis, and how many of them are contract staff only? Secretary. Thank you, President. Thank you, Dr. Wong. I want to give a reply to 2 points. First of all, we have 50,000 teachers in the teaching force, a 5% wastage rate, including retirement, change of jobs, etc. Then it means that we have 2,000 vacancies, and every year we have about 1,000 prospective teachers wishing to join the teaching profession. So in terms of the numbers, I think this can be addressed, as mentioned in my main reply. But we do understand that there are different subjects, and then teachers have different preferences. So sometimes a teacher may start as a contract teacher. As I've mentioned, over 90% of them are already working under staff establishment, and many schools are already working hard to provide permanent posts whenever the opportunity arises. So this is part of the arrangements, and we have made a lot of progress. Over 2/3 of the situation has been improved, and 25% of the schools do not have contract teaching posts. Not answered. For those newly joined teachers, I want to know how many of them are having teaching contracts as the mode of employment. Secretary, do you have the information? The established system does not provide for this data. I have talked to the Institute of Education. I've been told that 90% or more of their graduates can find a job. For the rest, I think they have their own arrangements and they have their own preference. We have to understand that this may not be the ideal situation, but then between work and schools' needs, I think there is always a difference. Do you have the figures concerning the number of teachers working as contract teachers and those on permanent basis? According to our statistics, 90% of the teachers are working under the staff establishment. And then for the rest, if I remember correctly, I think 5 or 6% of them are working under a contract. Secretary, please provide the data after the meeting. Ms. Chen Yun-hen. President, I think this is about teaching manpower. Well, I do sit on the management committees of schools. I can see that for a long time, teachers have a lot of grievance. It appears that the secretary doesn't find that there is a problem, and he's citing the experience of South Korea, etc. I think he doesn't know the situation. In fact, their workload is huge. Every day they have long working hours. So, Secretary, please try for 1 week's time and work as a teacher in one of the schools. Please ask a question. My question is, Mr. President, many teachers are asking this question. That is, how come that for the same qualifications, teachers are given a different pay package? So in terms of teaching manpower, I think the administration must address this problem. For equal qualifications, they get different pay. So please address this problem. You have asked your question. Please allow the Secretary to answer it. Thank you, President. Thank you, Ms. Chan. Well, in relation to the broader issue of workload as well as the pay package of teachers in primary and secondary schools, I think teachers and teaching assistants have got different we have got different requirements for them, and different schools have also got their own arrangements. I believe that overall speaking, I think the situation is acceptable. And then for workload, it also depends on the qualification and experience as well as the specific work arrangements. For DSS schools, usually their pay is higher. For public sector schools, and their pay levels may be lower. And for contract teachers, there may also be a different pay package for them. Ms. Chen. Secretary hasn't answered your question. Please repeat your question. I don't think he has answered my question. Please repeat your question. Now, teachers complain that they are very busy, and they complain that even for the same qualification experience, they get a different pay. The Secretary hasn't actually dealt with our views. I think the Secretary has answered your question. But if you're not happy with the measures already taken by the administration, please follow this up on other occasions. Mr. Frankie Yick. From the Secretary's reply, we can see that for a period of time in the past, indeed, we have got more subsidies and more permanent posts. But then this is applicable to all categories of schools. However, I don't think the administration is providing more resources to, say, schools in Band 3. Now, we have been told that students in Band 3 schools have a huge diversity of learning abilities, and they've also got students with special educational needs. So my question is, will the administration consider the following as a result of the differences among the three bands of schools? Would you provide a subvention of a different size? Say, for example, for Band 3 schools, is it possible to give them more subvention so as to help them to deal with the difficulties that they face? Secretary. Thank you. Yes, we agree that this is necessary. In particular, for schools in different bands, they may need more resources to support students with learning difficulties. We do have a support grant to allow schools to employ more teachers to help with students with learning difficulties.
Question number 4, Mr. Frankie Yick. President, in the past 4 years, among the top 10 solicitors in each year to whom the Legal Aid Department assigned the most legal aid cases, number of cases assigned to the solicitor on top of the list was higher than that to the solicitor ranked the 10th by roughly 80%. Given that LAD generally assigns, according to the wishes of legally aided persons, the solicitors or counsel nominated by them to be their representatives, and legal aid cases are assigned mainly to a small number of lawyers at present, some members of the taxi and public light bus trades are worried that the legal aid system is susceptible to abuse. For instance, lawbreakers may engage in championcy and abet the injured in traffic accidents to exaggerate the degree of their injuries sustained in order to make fraudulent insurance claims. Due to the increase in the amount of compensation payout, insurance companies raised the insurance premium for vehicles, resulting in an increase in the operating expenditure of the trades. So in this connection, will government inform this council, A, of the annual numbers of legal aid cases in which LAD refused the assignment of the lawyers nominated by the aided persons, with a breakdown by reason for refusal, the average, the highest and the lowest amounts paid for the legal costs, and other disbursements for unsuccessful legal aid cases, the average difference between the amount claimed and the amount of compensation awarded by the court in respect of the successful legal aid compensation claims, and the number of traffic accidents involving taxis and public light buses among such cases in the past 5 years. B. Whether LAD reviewed in the past 5 years the existing legal aid system, including the practice of nomination of lawyers by aided persons, the causes for legal aid cases being assigned mainly to a small number of lawyers, and whether allowing aided persons to nominate lawyers will give rise to problems such as champity. If it did, of the outcome and the solutions for the problems concerned. If not, whether it will conduct such a review, whether it will study the formulation of a code governing aided persons' nomination of lawyers so as to ensure that legal aid cases will not be assigned mainly to certain lawyers, and C, whether it will invite the Corruption Prevention Department of the ICAC to give advice on the existing procedure for assigning legal aid lawyers so as to ensure that the procedure is fair and transparent. If it will, of the details; if not, the reasons for that. Secretary for Home Affairs. President, the government's policy objective of legal aid is to ensure that no one with reasonable grounds for taking or defending a legal action is denied access to justice because of a lack of means. According to the Legal Aid Ordinance, legal aid will only be granted to applicants who pass both the merits test and the means test, and all legal aid applications are processed by LAD's Legal Aid Council. In assigning legal aid cases to lawyers, Section 13 of the LAO provides that where a legal aid certificate is granted, the Director of Legal Aid may act for the aided person through Legal Aid Counsel or assign any lawyer in private practice who is on the legal aid panel selected by either the director or the aided person. To this end, the LAD has devised a set of criteria on the assignment of legal aid cases, which have been endorsed by the Legal Aid Services Council and uploaded onto the LAD's website. In assigning legal aid cases to lawyers on the panel, the aided person's interest is of paramount importance to the LAD. When processing the nomination of lawyers, LAD will, based on the assignment criteria, determine whether the choice of lawyers is appropriate by assessing whether the nominated lawyer has attained the relevant seniority, experience, and expertise required to take up the assignment. If the nominated lawyer is considered not appropriate on grounds like having previous records of unsatisfactory performance in handling legal aid cases or currently handling an overwhelming number of legal aid cases, LAD will discuss the choice of lawyer with the aided person. When necessary, the LAD will ask the aided person to select another panel lawyer and assess whether the newly nominated lawyer is appropriate in taking up the case. As such, the lawyer eventually assigned to take up the case will be agreed to by both the aided person and the LAD. As regards the three parts of Mr. Yick's question, my answer is as follows. A. The LAD has not maintained statistics on the number of legal aid cases where the nomination of lawyer by an aided person was refused. The cost incurred in cases, irrespective of whether the lawyer was nominated by the aided persons, closed in the past 5 years relating to traffic accidents, employees' compensation, and general damages claims for personal injuries are set out in the annex. Meanwhile, all traffic accident cases, regardless of the types of vehicles involved, are classified under the traffic accident category. LAD does not maintain separate statistics on traffic accident cases that involved only taxis or public light buses. Regarding the amount of damages claimed for personal injuries and the judgment sum eventually awarded by the court, the amount claimed in individual cases would often be revised for various reasons in the course of the proceedings. As such, LAD has not compared the amount of damages claimed and the judgment sum eventually awarded by the court for individual cases. B. Under the common law, maintenance and champity are criminal offences and are prohibited under the Code of professional conduct of the Law Society of Hong Kong and the Hong Kong Bar Association. Notices are displayed at LAD offices to remind the public of the risk of engaging recovering agents and of the prohibition of improper touting activities by law firms within LAD premises. If a nominated lawyer is found to have engaged in any improper conduct, LAD will impose appropriate sanctions on the lawyer concerned and refer the case to the Bar Association or the Law Society for follow-up action. To address the public concern on improper touting or championship activities, LAD has introduced a declaration system for legal aid cases in September 2013 after having consulted the Legal Aid Services Council and the 2 legal professional bodies. The system seeks to ensure that the aided person's choice of lawyer is not affected by the improper touting or other conduct on the part of the lawyer concerned. A nominated lawyer who is unable to accept the above declaration condition will not be allowed to take up assignment to handle the case. Meanwhile, LAD has also noted that there were panel lawyers who had been assigned with a relatively larger number of cases. Such situations may not necessarily be related to improper touting or championship activities. LAD will consider enhancing liaison with the 2 legal professional bodies to combat improper touting and imposing appropriate sanctions on law firms that have acted unreasonably or have not handled claims properly. LAD also strives to enhance the transparency of the claims procedures and welcomes the provision of evidence and relevant information such as copying to the LAD correspondences between the defendant or the insurer and the aided person so that LAD may identify in a timely manner any improper conduct on the part of the assigned lawyers. Home Affairs Bureau and the LASC will closely monitor the situation. C. A departmental monitoring committee chaired by the director is established to evaluate the performance of assigned lawyers in handling legal aid cases and a number of legal aid cases assigned. In the past, a representative of the ICAC has attended DMC meetings as an observer. To enhance the transparency and fairness in the assignments of lawyers, LAD and ICAC have formed a corruption prevention group to discuss issues relating to the prevention of corruption and bribery. We understand that the group has agreed to commence a review of the lawyer assignment procedures in the middle of the year. The Home Affairs Bureau will closely monitor the situation. Furthermore, LAD currently has in place a mechanism for making representations regarding legal aid cases. If anyone believes that a person should not have been granted legal aid, for example, that a person has withheld essential information that affects the strength of the case, he or she can make a representation to the LAD. If verified after investigation, the LAD will discharge the relevant aided person's legal aid certificate. If improper conduct on the part of the lawyers is involved, LAD will also take appropriate actions, including issuing advisory letters to the lawyers concerned, placing their names on the record of unsatisfactory performance and conduct, removing their names from the legal aid panel, as well as referring the cases to the relevant legal professional bodies for follow-up action. Thank you, President. Mr. Frankie Yick. President, in his main reply, the Secretary said that the government's policy objective of legal aid was to ensure that no one with reasonable grounds for taking or defending a legal action would be denied access to justice because of a lack of means. But then there are some people abusing the legal aid system. They're making use of public funds to go to court and to make claims, and we are worried that the premium to be paid by public minibus and taxi operators will increase, and as a result the public will also suffer. Yes, we welcome the formation of the corruption prevention group, and we understand that this group will commence a review in the middle of the year. So will you invite people from the legal services sector and from the insurance sector and from the transport sector to give you more information to facilitate your review? Secretary, yes, the legal aid system seeks to make sure that justice is done. So of course, we are concerned about possible abuses of the legal aid system, and that is why the corruption prevention group has been set up, and in the middle of this year there will be a review concerning lawyer assignment procedures. Now Mr. Yick is suggesting that the HAB should invite the insurance sector as well as professional drivers and those from the public transport sector to provide information. And I understand that LAD has received complaints and has very seriously investigated those cases. And Mr. Frankie Yick wants to know whether the corruption prevention group comprising LAD and ICAC representatives will invite the relevant parties to provide information to the group to facilitate this work. And I'm sure the group will be interested in hearing about cases. Mr. Chen Kin-po, I understand that in many of the cases, lawyers' fees account for 30 to 40% or even 60% in some cases. And I've got this submission from the alliance of taxi and minibus operators, and they have these complaints. They are of the view that some name cards of law firms are being distributed, and then it is said that a person was injured in a traffic accident, and the original claim was only about $300,000. But then, after having received legal aid, the amount of claim rose to $3 million. So we want to the secretary to look into such cases. I think such cases are really alarming. Secretary, I have had a meeting with the Director of Legal Aid. He has indicated that he is most willing to receive the details of such cases, and he will carry out follow-up investigation. And concerning the first case, it's a very serious offense, because the allegation is that the staff have colluded with law firms. And of course, we will not neglect these cases, because these cases affect the credibility and the integrity of the legal aid system. Mr. Dennis Kwok. President, the legal services sector has all along been very concerned about the legal aid system, and legal sector's position is very clear. I understand that in 2012, a report was published, and to the effect that even if the legal aid department could not become an independent body, then the arrangement prior to 2007 should be reinstated. In other words, the LAD should come under the CS4A and should be directly responsible to the CS4A. Now, the recommendation was made in 2012. I want to know whether the Bureau will implement this recommendation. Secretary, we have very seriously studied the recommendation of the LASC. I understand that the recommendation is to put the LAD back under the CS4A. I believe there has been some communication with the LegCo. In June or July this year, there will be a report to be submitted to the AJLS panel. Mr. Ronnie Tong. President, I think in Mr. Frankie Yick's question, there is a very important point, and that is sometimes the lawyer ultimately representing the aided person is not the lawyer nominated by the aided person initially, and Mr. Yick has asked for such figures. All right, and the two reasons given by the secretary are unsatisfactory performance in handling legal aid cases, or the lawyer handling an overwhelming number of legal aid cases. Now, if it's the former, then the name of the lawyer should not have stayed on the panel. And then second, in the latter case, now can the secretary explain further? And for example, is it that you should approach the lawyer to see whether he can cope? So can you give us more information about the lawyers representing the aided persons, not the lawyers that were nominated by the aided persons? Secretary President, some lawyers are still on the panel, on the legal aid panel, but then they haven't really performed in a satisfactory manner, and this is one of the considerations. And then second, maybe the lawyer is at the same time handling an overwhelming number of legal aid cases, and that will of course be brought to the attention of the LAD or the director. In fact, there are some indicators used by the department. For example, for civil cases, generally speaking, a lawyer should not deal with more than 45 such cases in a year. And then for barristers, we don't want the number to exceed 25 per year. And I think this policy is also in the interest of the aided persons, and we do not want all the cases to be in the hands of one or two law firms. So I said that your question has not been answered. I asked the secretary whether the LAD would ask the lawyer concerned whether he or she would be able to cope with the caseload. Now, I think the secretary has already told you the existing policy and arrangements. If the member disagrees to the practice, then you should follow up on another occasion. President, it is not that I do not agree with him, but I just want him to answer my question. I think the secretary has already answered your question. Ms. Priscilla Leung, thank you. Legal aid is administered using public funds, and so there should be fairness. Fairness is very important, and I think the public rightly expect legal aid to be administered in a just manner. Now, some lawyers have asked me why some lawyers can handle more legal aid cases than others, and so I think there should be a fairer distribution of cases, and also the public are also concerned. Now, in the AJLS panel, there was a figure given to the panel, and we were told that in one case, in one legal aid case on the right of a boat, over $40 million was spent on the case. You know, many people want to get legal aid, and so will you consider broadening or widening the scope or the types of cases eligible for legal aid? And then second, 40 million per case, with the case going all the way to the CFA, then the resources will not be evenly distributed. So I just want to know whether you're going to impose a cap for cases that ultimately go to the CFA. Secretary President, for legal aid cases, we do not cap the spending or the expenditure. The objective is to make sure that justice is done. And if in a case we need to hire an expert and the duration of the case is very long and the cost is very high, and if we exceed the amounts that we have been allocated, then we will seek supplementary provision from the FC. Mr. Tam Yu Chong. President, in his reply to Mr. Ronnie Tong's question, the Secretary said that for civil cases, a lawyer should not handle more than 45 cases a year, and the figure for barristers is 25 per year. So I want to ask the Secretary whether he has got information concerning the last 3 years, whether there were solicitors or barristers exceeding such numbers, and if there were the reasons for allowing them to go beyond the optimum numbers. Secretary, President, in fact, we did provide some information to a question asked by another member earlier. In fact, there were cases where such figures or numbers were exceeded. According to the LAD, the decisions were made in the interest of the aided persons concerned. But then, at the same time, the LAD will try to administratively comply with such criteria so that in future cases of exceedance can be minimized.
Question 5, Mr. Wong Yuk-man. Thank you, Mr. President. The Commerce and Economic Development Bureau completed the assessment report on Hong Kong's capacity to receive tourists, that is the report, in December last year. The areas covered by the report include the handling capacity of boundary control points, receiving capacity of tourist attractions and the public transport system, supply of hotel rooms, economic effects of the individual visit scheme, IVS, and its impact on the livelihood of the community, etc. It stated in the conclusion of the report that it is necessary to enhance the overall receiving capacity of the industry on various fronts. Will the government inform this council in this connection whether it will set quantitative indicators of the upper or lower limits for the various aforesaid areas, so that when any relevant indicator for a certain area has been reached due to a rise in the number of visitors, the government will cease implementing policies which attract more visitors to Hong Kong? And as some scholars, after analyzing the data contained in the report, wrote articles in newspapers pointing out that IVS merely jacked up the rents of rental shops with no significant increase seen in the real income positions such as salesman, cook, office manager, etc. How the government will improve such a situation? Secretary for Commerce and Economic Development. President, tourism is an important pillar of Hong Kong's economy. The continuous growth in visitor arrivals has indeed brought challenges to Hong Kong, but has also boosted economic growth and promoted employment. Taking 2013 as an example, visitor arrivals reached 54 million, generating a total spending of $340 billion. Tourism, which accounts for 4.7% of our GDP, has been driving the development for many other sectors, including retail, food and beverages, and transport. These sectors employ over 250,000 people, including many jobs with relatively low-skilled requirements. The SARG is well aware of public concerns about whether the continuous growth in visitor arrivals would affect the livelihood of the community. In September 2012, the Chief Executive announced that the relevant mainland authorities would liaise and work closely with the Hong Kong SARG to ascertain the receiving capacity of Hong Kong before considering implementing multi-entry individual visit endorsements for non-permanent residents of Shenzhen and arranging the orderly issuance of exit endorsements for non-permanent residents, that is, 1 entry or 2 entry endorsements in 6 cities. The SARG also conducted a comprehensive assessment on Hong Kong's capacity to receive tourists. The areas considered include the handling capacity of boundary control points, capacity of tourism attractions, receiving capacity of hotels, carrying capacity of public transport networks, impact on people's livelihood, and economic impact, etc. The assessment report was completed at the end of last year. It does not recommend setting a limit on visitor arrivals, yet it acknowledges that with the continuous growth in visitor arrivals, Hong Kong should increase the capacity to receive tourists. We understand that over-concentration of visitors would exert pressure on the community. We'll continue to enhance our capacity to receive tourists on many fronts. Firstly, we endeavor to increase the supply of hotel rooms, including actively identifying ways for the gradual release of 6 sites facing Victoria Harbour within the hotel belt adjacent to the Kai Tak cruise terminal to the market starting from the end of next year. Second, the hotel project at the Murray building site has been successfully tendered. Upon commissioning, this hotel, with the Ocean Hotel in the Ocean Park and the 3rd hotel in the Hong Kong Disneyland, will provide over 1,500 rooms. Second, on the tourist facilities, the Ocean Park Corporation will develop an all-weather indoor-cum-outdoor water park at Tai Shu Wan. It's expected to be completed in 2017. The Hong Kong Disneyland will build a new themed area, Based on the Ironman experience, the terminal building and the first berth of Kai Tak Cruise Terminal came into operation last June. The second berth is to be commissioned this year. Regarding the relatively long-term planning, we'll actively plan for the development of the Kai Tak Fantasy and Lantau into 2 specialized tourism clusters to attract the high-value-added visitor segments. Kai Tak Fantasy International Ideas Competition on Urban Planning and Design is now underway, and it is our target to turn the site into a spectacular world-class tourism, entertainment and leisure hub. At the same time, we'll strengthen promotion of tourist offerings in different districts so as to offer more choices to visitors and to alleviate congestion at traditionally popular tourist areas. We also hope to broaden the overall economic benefits brought about by the tourism industry to all Hong Kong residents through encouraging visitors to explore, visit and spend in different districts. The SARG will do our utmost to balance the impact of the tourism industry on Hong Kong's economy and the livelihood of our community. We also have to prepare for the future so that Hong Kong will stand ready to provide pleasant experience for tourists from all over the world, regardless of the ups and downs of the economic cycle, and to ensure the healthy and sustainable development of the tourism industry as one of Hong Kong's economic pillars. As pointed out in the assessment report, the IVS contributes positively towards the overall Hong Kong's economy. In 2012, the IVS visitors spending directly generated $26.1 billion in value-addedness, equivalent to 1.3% of GDP and over 110,000 jobs, that is 3.1% of total employment. Amongst the sectors directly benefited from the IVS contributed the most to the retail sector in terms of value-addedness, followed by the hotel sector. Also, in the course of their operations, these economic sectors generated demands for services of other sectors, which further contributed to the overall economy. In fact, members from different sectors also consider that the IVS helps drive overall economic development as well as providing job opportunities to the grassroots workers. For example, benefiting from the IVS, the prosperous development of the hotel sector creates a continuous demand for relevant labor. Therefore, in recent years, the hotel sector has collaborated with recruitment websites from time to time to attract more talents to join the hotel sector by holding large-scale job fairs. In addition, representatives from the retail sector have pointed out that the IVS has boosted Hong Kong's retail sector, and the IVS visitor spending has given rise to more than one-fold increase in our retail sales over the past 10 years. Meanwhile, the IVS also brings many business opportunities to the food and beverages section. F&B sector. Industry representatives estimate that mainland visitors contribute about $5 billion to our F&B sector every year. As far as employees in related sectors are concerned, apart from creating employment, information suggests that the IVS also helps increase their real income. A recent survey found out that among some 400 frontline employees in the retail sector, more than 70% of the respondents consider that the IVS is conducive to the company's turnover and their own income. Among these, 38% of these see substantial benefits. The organization which conducted this survey also considers that the IVS has a positive impact on Hong Kong's economy and provided opportunities to grassroots workers for employment and pay increases. The healthy development of tourism industry plays a critical role in promoting employment. We will continue to make greater efforts to enhance our capacity to receive tourists on various transfers to ensure the stable and orderly development of the tourism industry and to minimize the inconvenience of the increasing visitor arrivals caused to local residents. This was a balance between the impact of the tourism industry on Hong Kong's economy and livelihood of the community. Mr. Wong Yuk-man, Mr. Secretary's written reply lasted 7 minutes, but that can be found from the website. But basically, it's not answered my 2 questions. I'd like to ask a follow-up question. Now, you mentioned something about IVS and our receiving capacity. We would like to enlarge our effort. Well, you sounded very grand, but you did not mention the demerits. Higher rentals and commodity prices, environmental and traffic congestions, and conflicts between the mainland and Hong Kong. Every Sunday, there are these demonstrations to ask for curbing triad activities, communist activities, etc., as well as these mainland tourists. we continue to receive so many tourists. You did not mention that in your reply. All your words are empty, hollow, and sounded grand only. We have these local campaigns to anti-communist ends as well as anti-trade ends. How are you going to ease the conflicts involved? Secretary, I'd like to thank Mr. Wong Yuk-man for his questions. In recent times, there have been disturbance cases for the visitors. Well, they're expressing their personal views on IVS, leading to environmental, traffic congestions, and rising rentals and commodity prices. Sorry, Mr. Wong Yuk-man, I have to stop you. For this part of our meeting, we cannot allow for debates. Therefore, members, when the Secretary is speaking, please do not interrupt. Secretary, Mr. President, in recent times, such incidents have actually tarnished our reputation as a tourist attraction and have also affected the retail shops as well as our economic activities. These disturbing cases in relation to visitors have affected us. We should publicize our culture of hospitality towards visitors, and through the internet and publicity materials, we should urge visitors to understand more about Hong Kong's community. On various occasions, I mentioned that for economic development, the tourism industry is actually benefiting our economic development. At the same time, we have to balance that with people's livelihood. It's precisely because of that that we've conducted the survey. On various fronts, we've tried to boost our capacity. In that assessment report, there are a great deal of objective data to support us. In terms of traffic and transport, for example, indeed, in busy areas, our visitors have exerted pressure on our transport system. The Transport and Housing Bureau has adopted various initiatives to cope so as to minimize the impact on local residents. Mr. Wong Kwok-in, thank you, President. In the Secretary's reply, the Secretary mentioned a lot of economic merits and employment opportunities brought to Hong Kong. Well, we do not disagree to those remarks, but the Secretary did not mention the other aspect, that is, disturbances caused to our residents, rising commodity prices, rentals, and the monopolistic nature of our retail businesses, and congestion in tourist attractions. Many of these attractions have been our local residents' attractions as well, but because they're so crowded at the moment, locals dare not go there. Now, this has been causing disturbances to both visitors and locals. Now, we do not support the driving away locals activities, which actually adversely affected Hong Kong. As for the boosting efforts for receiving capacity, it will take a few years for those efforts to produce results. In the interim, will you try to balance the number of IVS visitors and the impact on Hong Kong? First of all, you should do away with the multi-entry individual visit endorsements for non-permanent residents for Shenzhen and the other 6 cities. For example, can you cut the IVS visitors by a quarter in number so as to balance the number of visitors with the impact on Hong Kong? Secretary, all along, the SARG and the mainland authorities have been very concerned about this issue. In order that our tourism industry will develop in an orderly and gradual approach, the CPG has agreed to reducing the scope of the IVE for Shenzhen and other 6 cities. And then in September 2011, that endorsement scheme has been suspended for the time being. This is to take into consideration the needs of Hong Kong. That is, while developing tourism, we have to balance that against the impact on people's livelihood. The SARG closely liaises with the mainland authorities to reflect the actual circumstances of Hong Kong and to cope with the effort of the CPG. We'll continue to do that. The Secretary did not answer my question directly. My question was, in the short term, will transitional arrangements be considered? For example, those multi-entry measures or 1 entry or 2 entry endorsements that I just mentioned. Secretary, as I said, we'll closely monitor the actual circumstances of Hong Kong and liaise with the mainland authorities. For example, crowdedness in tourist attractions. Precisely, this is about receiving capacity. That's why we have to boost our receiving capacity, for example, in terms of the number of hotel rooms. At the moment, we have 70,000 hotel rooms. In the next 3 to 4 years, that will be increased. Well, another 18,000 rooms will be added. Well, Mr. Wong asked, in the next 3 to 4 years, what transitional arrangements do you have? Well, in the next 3 to 4 years, we'll be completing those new hotels. As I said many times on other occasions, we will adopt streaming measures for incoming visitors, and along the boundary, we'll also set up shopping facilities. In terms of planning and other areas, from the standpoint of tourism, we of course want to see these facilities completed as soon as possible. Mr. Vincent Fang, Mr. President, my sector is very much in support of the contents of the assessment report. That is, no ceiling should be set for the number of visitors. We agree to that because no other jurisdiction has ever set any ceilings to the number of visitors. You mentioned 54.3 million visitor arrivals at the moment to be increased to 70 million. Have you ever analyzed these figures? How many of them are under the multi-entry system? How many visitors have been going in and out of Hong Kong once every day or more than once every day? And some visitors came to Hong Kong, went to Macau for a day and then came back. So in terms of entries, the figures may be doubled. So don't use the figure of 70 million to scare us. There may be a lot of double counts in this figure. Have you ever analyzed those figures? Secretary, I'd like to thank Mr. Fang for his question. 70 million is the figure for 2017. So for the time being, I really cannot give you any detailed analysis. But in 2013, in terms of data, how many overnight visitors and how many non-overnight visitors, among the overnight visitors, how many went to different districts, etc. We have these data. Because we have a great deal of data, I'll send you a written reply for the 2013 data. Mr. James To, Mr. President, the Secretary very often mentioned more tourist attractions, more hotels, and so forth. I just want to focus on one aspect, that is the transport capacity. The Secretary has to understand that at the moment, for Hong Kong people, if you take the MTR, you may have to wait for 4 to 5 trains before you can board one. The MTR is burst to, it seems, will any riot occur because of overcrowdedness of our transport systems? I did ask the Secretary that question. Has he ever considered our receiving capacity in this regard? Even if we are to introduce new tourist attractions and hotels in different districts, will the increased visitors not take our public transport systems, like the MTR? Secretary, President, Mr. James To mentioned the public transport systems. Take, for example, our MTR system does not have any safety problems. According to data given to us by the relevant stakeholders, for the MTR during the busy hours in the morning, indeed, it's reaching more than 90% capacity. For example, from Taiwan to Kowloon Tong for the Israel and from Yau Tong to Chung Kwan O, they are already saturated. That I understand. If our rail system has reached saturation, members of the public will have to wait. The THB understands that. We've provided a great deal of information on short-term and long-term initiatives for improvement. Take, for example, enhanced frequency for trains, new signal systems, and so forth. Given the existing signal systems, some rail lines, even before reaching saturation, will increase frequencies so as to minimize the inconvenience caused to the public. We fully understand that. Just now, Mr. To mentioned transport and how visitors have been using our transport systems. I don't have the data in hand. I asked whether you have considered the possibility of riots resulting from such overcrowdedness. Secretary, in the assessment report, receiving capacities have been assessed objectively on various fronts. Mr. Poon Siu Peng. Thank you, President. Mr. Wong Yuk-man said the scholars have analyzed the report and pointed out that the IVS merely jacked up the rents of retail shops, with no significant increases seen in the real incomes of positions such as salesmen, cooks, etc. Just now, the Secretary said that tourism is an important economic pillar, and the employees of the relevant sectors have seen actual rise in salaries. The assessment, a recent survey points out that amongst the 400 frontline employees responded to the survey, over 70% said that the IVS has been helpful to company turnover and income. From 2009 to 2013, rentals have risen by 46%, and over 20,000 employees were only receiving the minimum statutory wage, and many of those employees have been working for over 50 hours per week. I'd like to know how the administration can ensure that employees do share in the economic fruits of these initiatives. Secretary? Well, these are economic activities. From the economic point of view, if there is growth in demand, commodity prices will rise. The tourism industry has led to economic growth. In my main reply, I mentioned that the number of employees has increased as a result rather tremendously, and revenue from the tourism industry has also risen. And 70% of the respondents in the survey said that the IVS has been helpful to income rises. As for individual trades and industries, in hand, I don't have data on the impact of the IVS on various sectors, but I understand that the survey findings obviously reflect that the IVS has positive impact on us. We've spent over 23 minutes on this question.
Mr. James To, President, the Working Group on Civic Education under the Central and Western District Council held a meeting on the 6th of this month to scrutinize funding applications for basic law promotional activities. At the beginning of the meeting, the chairman of the working group refused to allow
members of the public and journalists to observe the meeting, an argument then erupted between the district council member present at the meeting and the chairman about the arrangement. The journalists at the scene were evicted from the meeting venue by security guards afterwards, and that DC member was carried away from the conference room by police officers. In response to the above incident, the chief executive said that the police have all along acted in accordance with the law, and the commissioner for police pointed out that the police had the responsibility of ensuring the peace of society. However, some members of the public have raised concerns and query whether the police have abused their power and intervened in the operation of DCs. In this connection, will the government inform this council A, of the number of police officers arriving at the scene on that day to handle the incident, and the handling methods proposed by them, whether the police officers at the scene received any request for carrying the DC member away from the conference room, whether they had sought the approval of their superior officers before taking the action, whether they had explained to the DC member the reasons for carrying him away, how they had carried him away, and why they did not allow him to return to the conference room. 2. Whether there was any serious act of violence at the scene when the argument erupted among members of the working group. If so, of the details. If not, as the working group was holding a meeting in the DC conference room at that time, of the legal basis for the police to carry the DC member away from the conference room and obstruct him from discharging his duty of attending meetings. The meaning of acted in accordance with the law and peace of society as referred to respectively by the CE and CP, the legal basis for their aforesaid remarks. And 3, whether it will review if the police have abused their power in the aforesaid incident and of the measures in place to prevent the recurrence of similar incidents so as to safeguard DC members' right to attend meetings and ensure that the operation of DCs is free from any unreasonable police intervention. Secretary for Security. President, according to the laws of Hong Kong, under Section 10 of the Police Force Ordinance Cap 232, the police have the duty and power to take reasonable and appropriate measures to preserve the public peace, protect personal safety, prevent crimes and injury to property, etc. Upon receipt of requests for assistance from the public, in case of unforeseen or emergency incidents, the police shall perform their statutory duties by immediately deploying officers to the scene to understand the situation, provide assistance, or conduct investigations. After arriving at the scene, police officers shall take reasonable and appropriate actions in the light of the circumstances to preserve the public peace, protect personal safety, and prevent injury to property. Unless otherwise specified in the law, the police are required to discharge their statutory duties at public and private places. Actions shall be taken by the person in charge or security personnel at the scene to handle disorderly conduct at a private place. Only when the peace is breached or there is a threat to personal safety will police officers take reasonable and appropriate measures to intervene or provide assistance in a bid to ensure public peace and safety of the people at the scene. My reply to Mr. James To's question is as follows. 1 and 2. Upon receipt of a request for assistance in the afternoon of the 6th of March 2014 about somebody creating a nuisance in a meeting room, the police deployed officers of a patrol subunit to the scene for rendering assistance. Despite repeated requests from the person in charge of the meeting and the security personnel, 2 persons at the location refused to leave, and the deadlock extended into the early evening. One of the aforesaid persons struggled with the security personnel on a number of times, while the latter attempted to remove the persons from the meeting room. During the scuffle, a security guard fell onto the ground. The person in charge asked the police officers at the scene to pay due regard to the situation and to give advice on the means to handle the incident. The police officers clearly explained to the person in charge that any disorderly conduct should be handled by the security personnel, and that the police would intervene in circumstances such as a breach of the peace was likely to occur
or had occurred, or when harm was likely to be done to any person. The security personnel once again asked the person to leave the meeting room, but to no avail. In the process, there was again a struggle, and hence confusion, during which a security officer fell to the ground. Having contemplated that the scenario became chaotic again, the police officers, with due consideration of the safety of all persons at the scene, and after giving their advice to the person involved, assisted the security personnel to bring that person out of the meeting room as a means to prevent further aggravation of the conflict and to safeguard any persons from injury. The other person was removed by other security guards from the meeting room at the same time. During the incident, the police officers on the spot, while playing an assisting and mediating role, remained neutral in the course of discharging police duties of preserving the public peace and protecting personal safety pursuant to Section 10 of the Police Force Ordinance. Their actions on that day were by no means any interference in the operation of the Council. As at the 20th of March 2014, 2 complaints have been received by the Complaints Against Police Office or CAPO in respect of the incident. The CAPO is handling these cases in a fair and just manner according to the statutory mechanism of handling complaints against police. 3. Management of district council venues are under the purview of the respective district officers. When necessary, security guards may be arranged to assist in security matters like maintenance of order of the meeting and handling of possible disorder at the venue. According to DC's standing orders, the chairman of the respective meeting may issue warnings to a person attending or sitting in on a meeting whose behavior may disrupt the orderly conduct of the meeting. The person may be ordered to leave the place of the meeting if the misbehavior persists despite warnings. In such circumstances, the security personnel may, under the instruction of the chairman in charge of the meeting, escort the person concerned out of the meeting room. As mentioned above, the police handle all reports in an impartial manner, irrespective of any individuals calling for help in case of an incident or any councils requesting for assistance. When a breach of the peace is likely to occur or has occurred, or when harm is likely to be done to any person, the police will intervene by taking reasonable and appropriate actions in light of the circumstances to preserve public order, protect personal safety, and prevent injury to property. I have to reiterate that the police officers handled the case on that day in accordance with the normal procedures upon receipt of a request for police assistance. The actions taken were in no way or by no intention an intervention of the DC's operation, so there is no question of any abuse of power by the police. Thank you. Mr. James To. Well, President, as we know, district councils are already dominated by the pro-establishment camp. In particular, the chairmanship of the DCs have been dominated by the pro-establishment camp. All right, if a member would just like to increase the transparency of the meeting so that the meeting can be made open, if he just use verbal language to try to get things done instead of using violence, and then can the police officer exercise their own independent judgment so that the district councillor should have the right to stay on in order to argue with the chairman to get the meeting open to the public? Secretary, as I explained very clearly, well, the police received a request for assistance, and then they went there to render assistance, and then upon arrival at the scene, the police officers stayed there for an extended period of time without taking any action. Well, when a person in charge of the meeting or chairing the meeting made a decision, then of course is his own decision in accordance with the power given to him by the relevant institution or council. Well, in the course of the event, the chairman or the person in charge asked the security personnel to escort somebody away from the meeting, and the security guards did attempt to do so on a few occasions, but then there was scuffles and somebody fell to the ground. And then in the end, police officers, while the security personnel made further attempts to asked the person to leave the venue, and then that security guard fell to the ground, and then the police officers judged that if that should continue, then somebody might get harmed or injured. In the circumstances, the police officers assisted the relevant parties to assist the security personnel to remove that person from the venue, and the police job stopped there. With regard to the operation of the council meeting, the police officers did not intervene in any way. Your question has not been answered, Mr. To. Well, in my question, all right, when you remove a member from the meeting, you're actually intervening the operation of the council. So you should have exercised your judgment to see if the DC member has a right to stay on. I think the secretary has already answered your question. If you're not happy with that, you can also raise that on another occasion. Ms. Emily Lau. Chairman, I'm also following up on this point because at different levels of our institution, DC members or other members are very concerned about their right to attend meetings. All right, in the light of the incident, has the administration reviewed the situation where there are such disputes or conflicts? Does that mean that police officers can go to the scene? Yes, I understand that there was a dispute, there was an argument, and then can they just carry away that member? So have you reviewed the situation? Is that the best approach, or are there any alternative ways so that they could perhaps suspend the meeting so that both sides can sit down and work things out? So in the light of the incident, have you reviewed the situation, or are you still insisting that this is the best approach, and in future incidents, whatever happens, I'll just ask the police to come and remove you from the scene? Secretary, with regard to the operation of the district councils, of course, is for the district council's relevant standing orders to regulate. The chairman, as to how far his powers extend, is not for us or the police to say anything about. But then the police officers' duties were just to mediate, and 2 police officers and 2 PCROs were sent there. And throughout the incident, if you look at the development, well, it took several hours, and most of the time the PCRO was present, and the person in charge of the meeting also asked the police officers what advice they would give to the meeting, and the police officers also clearly explained to them that, well, they were present at the scene, and as I said, only where the situations that I referred to arise would they take reasonable and appropriate measures to deal with the situation, and they would not intervene with anybody attending the meeting, including the decision made by the person chairing the meeting at the time. With regard to what district councils are going to do in the light of the incident, well, that's for them to discuss. I was asking whether or not you had reviewed the situation. It's not just about your bureau. I think the entire administration, together with the district councils, should review the situation. If you're not able to give an answer today, can you give a reply afterwards to show that the relevant parties have already reviewed the situation, so that when similar incidents occur in the future, how are you going to deal with the situation? Anything that you'd like to add, Secretary? President, the Home Affairs Department, in its paper to the security panel, there was a written question and there was a written reply, and in paragraph 11 says this: well, in dealing with district council's internal issues, well, the working group under the Central and Western District Council will be reviewing the incident involving the working group, and that was the working group that you referred to, and also the application of the relevant standing orders. So I hope that I've already addressed the issue raised by Ms. Emily Lau, Mr. KK Fong. President, well, as a member, in particular an elected member, his statutory duty is to represent his voters, and of course it's his inherent duty to stay on in the meeting in order to reflect the views of his voters. And in paragraph 2 of the Secretary's reply, I'd like to read that up here. Well, police officers would only take appropriate actions when the peace is breached or there is a threat to personal safety, and then subsequently the security personnel again invited the person to leave the room, and there was another scuffle, and the security guards fell to the ground. So because of the chaos that arose, the police officers were of the view that personal safety was under threat. So can the two be equated? And also, have you found out why the security guard fell to the ground? Was it because he was pushed to the ground, or was it because he was in the process of pushing somebody to the ground and that's why he fell to the ground? Who caused the fall of the personnel to the ground? And if it's not caused by the district councillor, then why are you removing this district councillor from the meeting room? Secretary. Well, when the police officers assisted the security personnel to remove the relevant persons from the scene, well, according to the police officers, well, in fact, on YouTube, there were 2 clips that were shown, and I'm sure members will be able to review those 2 clips. I think it's better instead of having me repeating what happened and the judgment that I might have on what was happening on the ground. Well, as I said very clearly in my main reply, the police officers had their standard procedures to follow. That is, when there was a scene and they were of the view that somebody might be injured, that's why they had to discharge their statutory duties, and that would be the end of it. And then the police officers believed that in the course of a scuffle that might happen, and therefore they were assisting the security personnel to remove the person from the scene. And I believe that as you can see from the clip, and according to my understanding, actually, well, at the scene there were not just one clip. I'm sure the relevant party might have a more detailed clip, and if you review the clip, then you'll be able to come up or come to your wrong judgment. That's not my question. I was asking who caused the security personnel to fall to the ground. It could be caused by the security guard or the district councillor. So you cannot just ask me to review the tape myself. So I was asking you, well, what do you think? So when the security guard fell to the ground, was it caused by the person or the district councillor, or who or whom or which person at the meeting? Secretary, I've watched the 2 clips on YouTube, and the police officers, after judging from what was happening on the ground, whoever fell to the ground, well, while 2 parties were involved in the scuffle and somebody fell to the ground, and in the circumstances, the judgment of the police officers at the scene was that somebody might get injured. That's why they were there to help. So that's the perspective that they had adopted. Mr. Ip Kin-yuen, Mr. KK Fong, I think the Secretary has already answered your question. Mr. Ip Kin-yuen. Well, I'm a member from the Central and Western District Council. I think the situation is very clear, as you can see from the YouTube clip. Well, as you can see from the reply from the Secretary, all right, the security personnel was asking the district councillor to leave the scene, and after repeated attempts, there was this chaos, and as a result, the police officers assisted the security personnel to ensure that the district councillor would leave the venue. So that's what we now know, and I support the police officers' action, because during the 3-hour meeting, well, they were already delaying the meeting, and as a result, the meeting was not able to carry on with its business after 3 hours. So how can you say that it's not chaotic? I think it's very clear. Well, please ask your question. My question is, according to standing orders, the chairman could exercise his power under Standing Order 15.2. That's the Central and Western District Council standing order. So he discharged his duties under that, and if a member refused to leave, and as a result the meeting could not continue, and chaos arose, then can you just say that because of the political background of that district councillor and police officers, in the future, if that should happen again, does that mean that police officers would not enforce the law simply because of the political background of a particular councillor? Secretary, well, to answer your question directly, police act in accordance with the powers given to them by law, and they have this statutory duty to discharge their duties, and police action would not be influenced by any background of the person at the scene. So they would not be dealing with the situation differently because of the background of the persons involved. The police have absolutely not taken into account the political affiliation of the parties at the scene. In the end, the police assisted the security personnel in removing a particular person, and that was the only reason that they had acted in such a manner was that they could see that if the scuffle continued with a security personnel already fell to the ground, then somebody might get injured. In fact, earlier on, when the security personnel attempted to remove the person from the meeting room, there was already one occasion when the security personnel fell to the ground. He had to leave the room to take a rest. In these circumstances, the police came to the view that they had to discharge their statutory duties. So it's not because of the member attending the meeting, because of their political affiliation. That's why special action was taken. Mr. Albert Ho, Mr. Stephen Ho, while I did not read the printed press, so I couldn't remember the name of the district councillor concerned. So somebody asked whether or not the police would not discharge their duties because of the political affiliation of a particular councillor. So I also watched the tape. I was wondering how come the police officers only took action after such a long time. So I would like to know how come it was your judgment that you should only act after such a long time. Secretary, after the police officers arrived at the scene, we were monitoring the situation and how things developed. And on the first occasion, when a security guard fell to the ground, he was escorted up again very quickly. And then we believe that, and he said that he did not need further treatment and he did not need to see a doctor. So we could see that there were dialogues going on at the meeting. That's why in the early evening, so yes, a long time has elapsed. That shows that the police officers were neutral on the ground. So they only took action on one basis. That is that they believe that somebody might get injured, and then they try to render assistance. So at around 7 p.m. in the evening, when the security personnel tried to remove that person from the meeting, and there was a scuffle, and then somebody fell to the ground, and the police officers saw that someone got injured, and therefore they rendered assistance. As you must have watched that video, all right, for the clip online, that was a very short one. But then from what I've seen, well, someone might have taken the footage on an extended basis, and if we could all see the extended clip, then we would all be able to tell what happened. All right, we have already spent more than 23 minutes on this. I think we should stop here.